immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello everyone and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates and licensed immigration attorneys engage, learn and stay informed on the latest developments in US immigration. My name is GB Satusa and I'll be your host for today's session. Asylum in 2026, what applicants must know about credible fear, evidence and USCIS and or EOIR trends. Asylum law continues to shift, and for many applicants, the process in 2026 feels more complex and less forgiving than ever. From credible fear interviews to stricter evidence standards and evolving decision-making trends at USCIS and in immigration court, the margin for error has narrowed significantly. Understanding what adjudicators are looking for today is critical for anyone with a pending or future asylum claim. To guide us through this critical and timely discussion, we are joined by attorney Sonyu Lau. With more than 33 years of legal experience, attorney Sonyu Lau is an experienced business immigration attorney dedicated to helping employers secure work visas and green cards for skilled professionals. He specializes in H-1B, L-1, E-2, O, and EB cases across diverse industries, including technology, finance, and hospitality. A graduate of Cardozo School of Law, Sonyu is licensed to practice in New York and is an active member of the American Immigration Lawyers Association, AILA. Attorney Sonyu, thank you so much for joining us today.
Thanks for having me.
I think you're mute there, attorney. All right. Before we begin, a quick reminder. ImmigrationQuestion.com is not a law firm and does not provide legal advice, representation, or services. This platform serves as a public meeting ground where individuals can learn about immigration topics and engage with licensed attorneys who participate independently. To everyone joining us on Facebook, YouTube, LinkedIn, and other platforms, welcome. If you haven't subscribed yet, now is a great time to do so. Grab your notepads and let's dive right in. Attorney Lau, as asylum policies continue to evolve, what are the most critical changes applicants should understand heading into 2026, particularly at the credible fear interview stage?
So with respect to credible fear interviews, you have to keep in mind that judges or the government attorney, when eventually case goes at that stage, you have to keep your story very consistent. If you are giving facts about why you are fearful of going back to your country, you have to be very specific. Why you cannot go back. If something happened in the past, which is typically called past persecution, you have to be very specific. On what date, what happened? Who were the people who threatened you? You cannot be vague when you are providing all those details. If you are being not very specific, it's likely the officer who's interviewing you at that stage might not find you credible, which will eventually lead to a denial of your asylum application. So being consistent and being clear is very, very important for credible fear interviews.
Right. Now, credible fear screenings are often the first major hurdle for asylum seekers. From your experience, what mistakes or misunderstandings most commonly lead to negative credible fear findings?
Couple of things with that regard. First, as I said, not being consistent and not being truthful. That's the most important part. When you are answering all these questions to the officer, you should be truthful. And your story should be explained in such a way that it appears believable, meaning the officer can believe you and say that whatever you are saying, it's true, that you actually have a fear to go back to your country so that you can go to the next stage of the process.
Right. Now, evidence requirements in asylum cases appear tightening. What types of documentation are USCIS and EOIR giving the most significant weight to now? And where do applicants most often fall short?
It's a very good question. So, immigration code gives a lot of importance to respondents' testimony. And if it is writing in detail, it has a lot of weight also. In addition, if people familiar with the facts of the asylum seeker's case, such as back home, maybe their family members, their friends, other acquaintances, if they can also give their written statement vouching for the asylum seeker's asylum statement, that is a lot of value. In addition, if you are a victim of any kind of physical harm and you visit a hospital or a doctor, then you can, of course, provide a medical report or a doctor's report. Or in another case, if you were threatened or you were harmed and you reported it to the law enforcement agencies, you can provide those police reports, etc. In addition, you can also provide country condition reports. Or if something happened to you and it got published in media, you can provide those media reports. In addition, you can also provide media reports about that particular circumstance in your country. Maybe you are a victim of a particularly violence that happened or reported in media widely, even though your particular incident was not reported in the media, but in general, if it was reported, you can provide those media reports. So these are the documents you can provide in support of your asylum application, and immigration code will give due importance to these kind of evidence.
Right. Now, we are seeing increased coordination between USCIS and EOIR. How are recent procedural or policy trends affecting asylum cases once they move from the asylum office to immigration court?
So in general, not asylum office to EOIR, but in general, we have seen increase in detention, meaning if you are in the US without a visa, meaning you entered after crossing the border and you have been in the US for less than 2 years, and our office has seen a lot of detention in such cases. And about the cases being transferred from USCIS to EOIR, in many cases we have seen where the people initially filed their asylum application with USCIS, even though they were already in the EOIR system. And then the asylum application typically gets rejected because the people will get notice that the jurisdiction is with EOIR, and then these people will have to submit their asylum application with the immigration code.
All right. Now, for applicants who filed under earlier standards or who are stuck in long backlogs, how should they for interviews or hearings under newer, stricter expectations?
So with regard to this, as we know that there is a pause on adjudication of asylum application. What that means is, even if you appeared for an interview at USCIS for an asylum interview, there will be no decision unless that pause is lifted. So you will have to wait for the decision at this time. On the other side, if your case is with the immigration court and you have been scheduled for the individual hearing, it can move forward. The immigration can judge and issue a decision on your asylum application. So that's confusing for a lot of people, meaning if you have already appeared for an interview with USCIS, there will be no decision on that since it is still pending with USCIS. If your asylum application is pending with immigration court, it can proceed, can proceed with individual hearing, the judge can still issue a decision on that.
All right. Now, looking ahead to 2026, what practical steps should asylum seekers and their advocates take now to strengthen their cases and avoid avoidable denials or delays?
It's a very good question. What we are seeing very recently in last couple of months, what is called motion to pre-terminate by government attorneys for asylum application. What it means is government attorney will make a motion to the court to pre-terminate, meaning don't even hear the case for an individual hearing and just deny the asylum application without even being heard. Why? Because the government attorney is going to argue there is no case to begin with. Meaning even if the facts stated in the asylum application are true, there is no ground or the person is not eligible for asylum. And we have seen a lot of cases, these kind of cases being pre-terminated, and the people issued removal orders. So if you are filing an asylum application, make sure you provide sufficient fact, and there should be a legitimate basis for an asylum case. If there is no basis to begin with, your case is going to be pre-terminated by the court. What it means is you will not even be heard.
Thank you. To everyone watching live, thank you for being part of this critical conversation. Asylum cases move through a system that is constantly evolving, and staying informed can make a meaningful difference in how applicants prepare, present, and protect their claims. If this is your first time tuning in, welcome. ImmigrationQuestion.com is a networking platform where immigrants and advocates can ask immigration-related questions for free and engage directly with licensed attorneys. Many users may also qualify for a free confidential consultation. We are also proud to share that ImmigrationQuestion.com is BBB accredited, reflecting our commitment to transparency, accountability, and community education. Now, Attorney Lal, with your decades of experience navigating complex legal systems, how do you see platforms like ImmigrationQuestion.com helping asylum seekers better understand current expectations and avoid common credibility pitfalls?
I think it's a great platform. It connects both sides, meaning it connects people who are looking for immigration attorneys, and it also helps immigration attorneys to find prospective clients. So I would say it's a great tool for both sides.
Thank you for that insight. Before we move into our live Q&A, one final question. For asylum applicants who feel overwhelmed by shifting standards and uncertainty, what mindset or preparation approach would you recommend as they move forward into 2026?
I would say immigration system itself is very, very complex. You cannot deal with it on your own. If you are seeking asylum in the US and if you do not have an attorney, I would recommend hiring an attorney. If you cannot afford an attorney, then probably look for various nonprofit NGOs if they can help.
If you've just joined us, we've been speaking with Attorney Sonyu Lal on Asylum in 2026, what applicants must know about credible fear, evidence, and new USCIS or EOIR trends. We are now moving into our live Q&A session. This is your opportunity to ask questions directly to a licensed immigration attorney. Drop your questions in the chat or call us live at 516-703-3483 and we'll take as many as possible. If I tell CBP I am scared to go home, do I get credible fear interview?
The general answer is yes. They will give you a credible fear interview.
All right. My friend filed asylum long time ago, but they have still not decided her case. Is there a pause on asylum decisions?
The recent pause was announced a couple of weeks ago, but we have so many cases which are pending for a long time with USCIS. So if you are in the same boat, what you can do is follow up with USCIS, see what's going on. And I would also recommend speaking to an immigration attorney, see what can be done on your case if it has been pending for a long time.
All right. How long does it usually take to get asylum interview after passing credible fear? Will it take months or years?
It should be within a couple of weeks if you have already been through the credible fear interview.
All right. Is credible fear interview the same as filing asylum?
No, it is not. It's totally different. So it's essentially it's a CBP at the border. When they're trying to send you back, they are doing a credible fear interview to assess whether you have an asylum claim or not. So they are totally two different things.
All right. When I show evidence about danger to my life, can they reopen my asylum case after they denied it earlier?
If the asylum case has already been denied, the only option typically would be to file an appeal with BIA. And there are certain rules and regulations for appealing with BIA. Typically, you should be filing a BIA appeal within 30 days. If the 30-day appeal has already passed, then I would recommend speaking to an immigration attorney if there is any other ground for a motion to reopen or reconsider with BIA.
All right. I failed credible fear interview. Can I ask a judge to review that denial?
Yes, you can.
Right. Attorney Lau, the Trump administration has expanded a full travel ban to additional countries, including Burkina Faso, Mali, Niger, South Sudan, Syria, Laos, and Sierra Leone. How should asylum seekers from these countries understand the potential impact of this policy on asylum access, credible fear interviews, and pending cases?
So this ban, which was recently expanded, now there are 39 countries subjected to this ban. There are countries subjected to full ban, countries subjected to partial ban. Countries which are subjected to partial ban, meaning nationals of this country, if they are outside US, they cannot come to US on visas such as B, F, and G. Other avenues are still open for them, but essentially the ban applies to people who are already outside US.
Thank you so much, Attorney Lau, for sharing your experience and practical guidance today. Your insight provides clarity for asylum seekers navigating a system that feels increasingly complex and demanding. And to everyone who joined us, thank you for being here. We hope today's discussion helps you feel more informed, prepared, and aware of what matters most in the asylum process as we move into 2026. Remember, you can always visit immigrationquestion.com to ask immigration questions for free and engage with licensed attorneys. Many users may also qualify for a free confidential consultation. If you'd like to revisit today's conversation or share it with others, the full replay will be available on Spotify soon. Just search for Borderless Talk by immigrationquestion.com. Join us again for our next live session covering critical immigration topics, including asylum developments, family petitions, removal defense, and policy updates. Until next time, stay informed, stay prepared, and stay connected.